In its simplest terms, a patent is an agreement between an inventor and a patent authority that grants rights to the inventor for a specified period of time. Frequently, those rights are referred to as intellectual property that can be licensed or sold. For most recent patents, the standard term for a patent is 20 years from the date of filing of the application, but this is subject to adjustments or extensions. When a patent expires, it is open to the public and can be used without risk of infringement. By agreeing to disclose an invention, the inventor receives the right to exclude others from practicing the invention without permission. In the United States, the first patent law was enacted in 1790. Quoting from the section of U.S. law granting the right of patent grants, Title 35 U.S.C., a patent provides the right to exclude others from making, using, offering for sale, or selling the invention in the United States or importing the invention into the United States. The basic laws for patents appear in the U.S. Code of Law, specifically U.S. Code Title 35, or as it's frequently referred to, 35 U.S.C. And Chapter 10 specifically details patentability of inventions. One of the most recent changes to the law, the America Invents Act, or AIA, is described in the note to Section 100 of Chapter 10. This changed the U.S. to a first-to-file authority and is in force with the effective filing date of March 16, 2013. Section 100 also provides definitions for commonly used terminology, such as inventor, the individuals collectively who invented or discovered the subject matter of the invention, and effective filing date as the actual filing date or the filing date of the earliest application for which the patent or application is entitled by right of priority. The Code of Federal Regulations, 37 CFR, provides additional rules of practice for patents, trademarks, and copyrights. A common reference for applying patent law is the MPEP, or the Manual of Patent Examining Procedure, used as a guidebook for patent examiners at the USPTO. Certain sections of 35 U.S.C. patent laws are well known, and they define what can be patented or the conditions for patentability. For example, 35 U.S.C. 101 defines what can be patented as any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement. A process is an act or method, including industrial processes and more recently business methods. Machine is a device with a useful purpose. Manufacture is articles that are made. And composition of matter usually refers to chemicals as new chemical compounds, but also includes compositions or mixtures of chemicals. In the United States, there are three types of patents. Utility patents are the most common type and build on the language already discussed in 35 U.S.C. 101 and may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement. Design patents are simple documents typically with a single claim that may be granted to anyone who invents a new, original, and ornamental design for an article of manufacture. And plant patents may be granted to anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. Patent kinds are codes that identify the type of publication and the publication stage. For a utility patent, prior to 2001, the A-kind code represented a grant. Starting in 2001, the U.S. published applications, so now the A-kind codes A1, A2, and A9 refer to the application publications, and B1 and B2 refer to the grant. The B1 would appear if there is a grant without a previous published application, whereas the B2 would represent a grant after a previous pre-grant publication. The S1 represents a design patent, and there are three kind codes for plant patents, P1, P2, and P3. The basic requirements for a U.S. patent are patentability, as described in 35 U.S.C. 101, utility or usefulness, meaning it possesses a real-world value, novelty, as described in 35 U.S.C. 102, which means it's not been described previously in prior art or available in public use or have been on sale. Non-obvious subject matter, as described in section 103, which means sufficiently different from what has been used or described before, so it could be said it would be non-obvious to a person having ordinary skill in the area of technology related to the invention. Possess a written description which describes the best mode or enablement for carrying out the invention. And this would be described in more detail in section 112, which includes information about the specification and the written disclosure, which typically includes examples and ends with the claims pointing out the subject matter that the inventor considers to be the invention.